General Christian Porter has warned that under existing biosecurity laws, Australians could be detained, and there is even a provision to shut down mass gatherings. Joining me now is the Attorney General Christian Porter. Thank you for your time, Attorney General. How long can you detain people under these laws?
Well, the power of detention is very much a last resort. People's consent is sought, and so this is for things like testing someone or requiring a sample and so forth, things that the overwhelming majority of people consent to. But there is an ability as a last resort in those circumstances, as there is in a number of other health laws, to have someone detained, but it's only for the purposes of allowing the thing to occur that you need to do, such as taking the sample or so forth.
So what kind of circumstances would you enforce them under the coronavirus?
Well, the COVID-19 circumstances that we're anticipating that we may face might require particular requirements on Australians coming and going from a certain place. So an example is if something like a fever clinic is established where people convalesce from the acute fever that you get with coronavirus. Most Australians are used to walking in and out of a hospital, fairly much without any restrictions, but it may be that in those circumstances, if it's considered on a medical advice and determined by the Chief Medical Officer and in consultation with his counterparts at the state and territory level, that you need further restrictive requirements, then they're the types of things that you could see occur here. I mean, one example is that the Diamond Princess, the cruise ship, that was declared under the Biosecurity Act a human health zone. So it was for that reason that we were actually able to organise the return of the Australians on that vessel to Australia in a way that our Chief Medical Officer had determined was safest for them, safest for their families, safest for the Australian community. So in general terms, it means that the government does have the ability to pose a number of restrictions in circumstances where people might not usually to have been restricted.
So, for example, international travellers, if someone arrives from overseas and they are showing symptoms of coronavirus, you're particularly concerned about them spreading infection in the community, they don't want to be detained. Can you forcibly detain someone in that circumstance?
If they're refusing to do a thing that we consider to be absolutely necessary, like undergo a brief decontamination or provide information about where they've been and who they've been in contact with, or potentially provide a sample so that they could be tested for the disease, then yes, detention is an option. And I must say that power under the Biosecurity Act is actually used quite regularly at our borders, at airports, in circumstances just like the one that you've described. But I think Australians would be less used to the idea that that power might be used at a clinic that was established or at a hospital. But the reality is that these laws were updated in 2015. Prior to that, our Quarantine Act dated back to 1908 and was more fit for a time when Australia got most of its vessels and incoming traffic by ocean liner. So we prepared by updating our laws in 2015 for precisely the type of circumstances where you may have to engage in pandemic planning, which very unfortunately we are doing at the moment.
Changing tack now, looking at the Foreign Influence Transparency Scheme, you've essentially remodelled this. It looks like Chinese influence, both covert and overt, will be the focus. Is that right?
Well, the legislation itself was never country-specific. We said that on a number of occasions. The application and enforcement of the legislation isn't country-specific, but yes, I wasn't overly impressed with the early stages of the operation of our resources and the application of our resources to making this act as effective as it can be.
Are you talking about the Tony Abbott targeting?
Oh, well, I thought that was ridiculous. I thought it was poor target selection. I didn't think it represented great triage or useful application of valuable government resources under the legislation. So we've undergone a range of changes with respect to the way in which we are applying our resources, and very much looking at the types of behaviours that might be registrable under the Foreign Influence Transparency Register, but those behaviours that occur in key sectors that are potentially of the greatest concern to Australians, and which Australians would most think they should know about. And this is, of course, a transparency register. There's nothing wrong with acting on behalf of a foreign principal, and we've had many, many registrations already under the scheme. What we're concerned about is those organisations which would meet the definition of a foreign government-related entity or foreign principal, have working for them people who may be engaging in registrable activities but haven't registered. So we're into a next phase, and we've certainly brought in some specialist expertise to focus on particular areas of the Australian economy.
Well, while you're in the business of overhauling, the sports grant scheme has become a bit of a joke, hasn't it?
Well, I must say there's been a number of sort of very extravagant statements made over the last several days in Senate estimates. I mean, we had Christina Keneally yesterday accusing the former Minister Bridget McKenzie of forging a document. I mean, accusing Bridget McKenzie under parliamentary privilege in a Senate estimates committee of a serious criminal offence.
But didn't we learn yesterday, Attorney General,
no
sorry to interrupt, but didn't we learn yesterday that the Prime Minister changed the projects in round 3 of this funding scheme on the day the election was called? That stinks, doesn't it?
Well, again, your characterisation of it relies on what I've got to say is assertions made by Labor members which don't actually bear out to the facts. On April 4, the decision by the Minister was made. Now, that was clearly the case. You've now got Labor ministers accusing the Minister of backdating that decision-making document, like forging a document. They're accusing the Minister of a criminal offence. Does it ever happen?
Backdating?
Well, it clearly did not happen here. The Minister has quite clearly said that that's not the case. But, you know, Laura, surely it's a matter of some seriousness when parliamentary privilege is used by Christina Keneally to accuse a former minister of a criminal offence with zero evidence. And they've got form here. The Labor Party and Mark Dreyfus have overseen 10 referrals of government ministers to law enforcement agencies for investigation for criminal offences.
Sure, but this is separate to that.
Zero
As a lawyer,
results.
you must be a bit embarrassed by some of
that,
the flimsy arguments that have been put forward by your side of politics as well.
Well, the sports grant program was run in accordance with the guideline. Now, people might take views about whether or not ministers should assert their own views as to the merit of programs over and above the views of the department. I happen to think that that is a fair and reasonable process, but I understand that people might have different views about that process. But allegations of criminal conduct by ministers with no evidence whatsoever to support that allegation, to me, that's the problem that's emerging here. I mean, how many times does the Labor Party have to make a false allegation, totally unsupported by evidence, refer it to the police and it doesn't get investigated for that to be an actual issue?
Okay,
like
but in the
20
interest
times,
of
50 times, 10 times?
That's a fair point, but in the interest of transparency, release the Gations report. Why not?
Well, the Gations report was a report which was a Cabinet deliberative report.
It never went to Cabinet though, did it?
Well, it went to a Cabinet committee, which means that it's a Cabinet deliberative document.
Have you seen it?
I was on the committee that the report was presented to for the purposes of Cabinet decision making.
Well, can you tell us what's in it that is so precious that can't be released?
Well, my legal view about that is the same legal view that Attorneys General of Liberal and Labor persuasion have taken for 100 years, and that is that documents which go to Cabinet for the purposes of deliberation and decision making are covered by Cabinet confidence and aren't released. Now, you know, that's been an essential principle of Cabinet government for 100+ years, observed by both sides of politics. So Cabinet documents don't get routinely released, as you know.
Christian Porter, we'll have to leave it there. Thanks for your time.
Thank you very much, Laura. Cheers.